the topic taken for discussion is quorum required for a general meeting and board meeting. The Companies Act 2013 requires that a company established under the Act has to hold general meeting as well as board meetings periodically. To ensure that the companies follow this regulation and that such meetings are held properly, it requires a quorum to be met for it to be deemed as a valid meeting. Quorum. The meaning of quorum. Quorum in simple word means the minimum number of members that have to be present in a meeting. Under the Act, the quorum for a general meeting, a board meeting and an extraordinary general meeting is enumerated within its provision. So the quorum required for a general meeting. Section 103 of the Act states the quorum required for a general meeting. So under this section, unless the Articles of Association of the company provides for a larger quorum, the minimum quorum must be satisfied. For public companies, 5 members to be present if on the date of the meeting being held. The number of members in the company should not exceed 1000. 15 members to be present if as on the date of the meeting there are more than that 1000 members but less than 5000 members. 30 members to be present if as on the date of the meeting there are more than 5000 members. For private companies. So in the case of a private company, regardless of the number of members, 2 members must be present for the quorum to be met for a meeting. Non-fulfillment of the quorum requirement. Subclass 2 and 3 of Section 103 of the Act provides for when the quorum has not been met. If the quorum is not present within half an hour of the time set for the meeting to begin, then the meeting will be adjourned and it shall be held on the same day and at the same time next week or any other date and time as the board may determine. If the meeting is adjourned, then the date, time and place of the meeting will be notified personally or via advertisement. The advertisement must be published in both English as well as the vernacular language in a newspaper which is in circulation at a place where the registered office of the company is situated. The meeting, if called by requisitionist under Section 100, shall stand cancelled. Under Subclause 3, if the quorum is not present at the adjourned meeting, then the member present shall be the quorum. The quorum required for a board meeting. A board meeting is a meeting that is held between the directors of a company. Such meetings are held usually to take important decisions about the company. To make sure that such decisions are not taken arbitrarily, the Act requires a quorum for the meeting and the decisions taken in the meeting to be valid. Section 174 of the Act provides the quorum for a board meeting. Section 174 subsection 1 of the Act. The quorum for a board meeting must be 1/3 of the total number of the directors or 2 directors, whichever is the higher number. Therefore, in case there are only 3 directors in a company, then at least 2 must be present, even though 1/3 would entail that only 1 directors need to be present. If the directors are not physically present, but they take part in the meeting via any audio-visual mean, they too shall be considered the part of the quorum. Section 174 subsection 2 of the Act. In the case where the quorum for a board meeting is not present, the director may only take two courses of action. They may act for the purpose of increasing the number of directors to that fixed for the quorum, or they may act to summon a general meeting. Section 174 subsection 3 of the Act, where the number of interested directors, that is directors who have invested in the company, exceeds or is equal to 2/3 of the board of directors. The number of not interested directors present at the meeting has to be at least 2 for the quorum. According to section 174 subsection 4 of the Act, in the case where the board meetings could not take place due to the lack of the quorum, the board meeting shall be adjourned. This is subject to the Articles of Association of the company. Therefore, as long as the Articles of the company states otherwise, the meeting will be adjourned. The meeting will be adjourned to the same time and the place as the original meeting on the same day the following week. In the case where the adjourned date is a national holiday, then the board meeting will be held at the same place and time on the following day. It is important to note the following while calculating the quorum. In the case when calculating 1/3 or 2/3 of the strength of the board of directors, if the final number is in fraction, then it have to be rounded off to 1. When calculating the strength of the board of directors, one should not take into account the directors whose place is vacant. Then the exception to quorum. A valid meeting may be constituted by the presence of one person in the following cases. If the meeting is an annual general meeting which was called by or on the direction of the registrar pursuant to section 131 subsection 2. In such a case, the section empowers the registrar to direct that one member of the company present in person or by proxy shall be deemed to constitute a meeting. If the meeting is one which has been called pursuant to a court order under section 135 subsection 1, the section empowers the court to direct that one member of the company present in person or by proxy shall be deemed to constitute a meeting. This is illustrated by the reference L. Sovereign Limited in the year 88. If the meeting is a class meeting held pursuant to the provision of the articles for the purpose of authorizing a variation of a right to those shares and all the shares are held by one member, as in East versus Bennett Brothers Limited in the year 94. If the meeting is an adjourned meeting and the article provides that the member or members present should be a quorum. Thank you.